Hi friends, this is CMA Deepika.bhugra Prasad, insolvency professional. The amendments 2025 to the code IBC 2016 have been proposed and have now been referred to the select committee. The much talked about issue is of the timelines, which is the essence of the original intent of the code IBC 2016. So friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the code IBC 2016 and to navigate through the intricacies of its proceedings. So let us today discuss a case about the timelines and that how strictly they have to be followed. So this is the case of Tata Steel Limited versus Rajkumar Banerjee and others, which was decided on the 7th of May 2025 by the Honorable Supreme Court of India. So let us see the factual background of this case. On 7th of April 2022, the Honorable NCLAT passed the order approving the appellant's resolution plan for the corporate debtor under Section 31 of IBC. On 23rd of May 2022, respondent number 1 e-filed the appeal along with an application for condonation of delay before the Honorable NCLAT. On 24th of May 2022, the physical filing of the appeal was filed. Now, in terms of Section 61, subsection 2 of IBC, the limitation period of 30 days for filing an appeal against the said order expired on 7th of May 2022, which fell on a Saturday. Now, what was the stand taken by respondent number 1? The resolution plan was approved by the Honorable NCLT on 7th of April 2022. The intimation of the said approval was given to the listing departments of the BSE and NSE only on 8th of April 2022. Since he was not a party to the petition filed under Section 7, he became aware of the approval on that date. Therefore, the 30-day limitation period for filing the appeal commenced on 8th of April 2022 and was set to expire on 8th of May 2022. However, since 8th of May 2022 was a Sunday, by virtue of Section 4 of the Limitation Act 1963, the prescribed period was extended to the next working day, that is 9th of May 2022, which was a Monday. Thereafter, the additional grace period of 15 days for seeking condonation of delay, as permitted under the proviso to Section 61, subsection 2 of IBC, expired on 24th of May 2022. Now, what were the issues before the Honorable Court? Whether the appeal filed by respondent number 1 was within the prescribed limitation period of 30 days, along with the additional condonable period of 15 days, as provided under Section 61, subsection 2 of IBC, and if not, whether the NCLAT has the power to condone the delay beyond the set prescribed and condonable period under the IBC. Now let us see what was the decision taken by the Honorable Court. First issue was computation of the limitation periods under the IBC. The total permissible period for filing an appeal under Section 61, subsection 2 of IBC is 45 days, comprising 30 days as the prescribed period and an additional 15 days that may be condoned upon showing sufficient cause. The benefit of Section 4 of the Limitation Act 1963 and Rule 3 of the NCLAT Rules 2016 extends the limitation period to the next working day if the prescribed period expires on a holiday. As per Section 61, subsection 2 of IBC, the limitation period for filing an appeal to the NCLAT commences from the date of pronouncement of the order by the NCLT and not from the date when the order is received or made available to the aggrieved party. Also, the benefit of Section 4 of the Limitation Act 1963 and Rule 3 of the NCLAT Rules 2016 extends the limitation period to the next working day if the prescribed period expires on a holiday. Now, the Honorable Court further clarified that while Rule 22(2) of the NCLAT rules mandates the filing of a certified copy of the impugned order along with the appeal, the limitation period is not contingent upon receipt of such a copy. However, if an appellant applies for a certified copy, the time taken to obtain it can be excluded from the limitation period under Section 12, subsection 2 of the Limitation Act. Thus, this decision underscores the IBC's objectives of ensuring timely resolution of insolvency proceedings, and the parties are expected to act diligently and within the prescribed timelines with limited scope for condonation of delay. Further, the Honorable Court in Sanjay Pandurang Kalate versus Vistra ITCL India Limited and others has pointed out that the date on which the limitation begins to run is intrinsically linked to the date of pronouncement. Now, the second issue was for the benefit of exclusion of period during which the court is closed. The Honorable Court clarified further that the benefit of exclusion of period during which the court is closed shall be available when the application is filed within the prescribed period of limitation, and shall not be available in respect of period extendable by court in exercise of its discretion. The term prescribed period, as defined under Section 2J of the Limitation Act 1963, and the scope and applicability of Section 4 of the said Act, has been categorically explained by the Honorable Court in various judgments, including My Preferred Transformation and Hospitality Private Limited and another versus Faridabad Implements Private Limited. Now, the third issue was IBC's strict procedural discipline. Now, the provision to Section 61, subsection 2 clearly limits the NCLAT's jurisdiction to condone delay only up to 15 days beyond the initial 30-day period, where a statute expressly limits the period within which delay may be condoned. An appellate tribunal cannot exceed that limit. Therefore, NCLAT, being a creature of statute, operates strictly within the powers conferred upon it. Unlike a civil suit, it lacks inherent jurisdiction to extend time on equitable grounds. The IBC prescribes strict timelines for filing appeals and taking action so as to ensure that insolvency proceedings are not misused to recover time-barred debts. Once the prescribed and condonable periods, that is 30 plus 15 days, expire, and the NCLAT has no jurisdiction to entertain appeals, regardless of the reason for the delay. The Honorable Court in Kalparaj Dharam Rishi and another versus Kotak Investment Advisors Limited and another SC has categorically held that the NCLAT cannot condone any delay beyond 15 days, even on equitable grounds. Thus, the NCLAT has no power to condone delay beyond the period stipulated under the statute. So, friends, we conclude that the Honorable Court held that the company secretary of the corporate debtor had duly informed the listing departments of both NSE and BSE about the NCLT order dated 7th of April 2022 within 30 minutes of its pronouncement. Hence, the limitation period for filing the appeal commenced on 7th of April 2022 and expired on 7th of May 2022. Notably, 7th of May 2022 fell on the first Saturday of the month, which is a working day for the registry of the NCLAT. Even otherwise, the benefit of Section 4 of the Limitation Act 1963 cannot be granted, as respondent number 1 filed the appeal beyond not only the prescribed period of 30 days, but also the condonable period of 15 days, that is on 24th of May 2022. Now, time is of essence in statutory appeals, and the prescribed limitation period must be strictly adhered to. Even a delay of a single day is fatal if the statute does not provide for its condonation. The Honorable NCLAT has no power to condone delay beyond the period stipulated under the statute. Allowing condonation in such cases would defeat the legislative intent and open the floodgates to belated and potentially frivolous petitions, thereby undermining the efficacy and finality of the appellate mechanism. The order dated 14th of December 2022, passed by the Honorable NCLAT, was set aside and the appeal was allowed. So, friends, we see how the courts are so strongly trying to protect the timelines and to ensure that the IBC actually achieves the purposes for which it has been promulgated. So friends, I hope that you find this both interesting as well as enlightening. So for further insights into such judicial pronouncements under the code IBC 2016, please like this video and subscribe to my YouTube channel. So thank you friends for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.